I've been asked to speak to you about the legal issues arising in this area in Ireland, and I propose to approach my topic in the following way. First of all, I want to say a few words about the manner in which the so-called progressive political project has been advanced through judicial decisions. The tactics used in many breakthrough cases were utilised in Ireland in the Fleming case, the judgment which summarises the current state of Irish law, and that will be the second issue that I'll be speaking about. Third, in light of the Fleming decision, I ask whether a constitutional change is required to allow for assisted suicide. And fourth, I consider recent proposals for legislation in the area. And then finally, to sum up, I offer the view that the unavoidable question at the root of everything in this field is the moral quality of suicide itself, and suggest how a society that wants to make progress in the right direction should answer that question. A few days ago, I was speaking with a young student who described the introduction of assisted suicide as progressive. The word progressive is one which today is semantically overloaded. At one level, in a finite world constrained by time, the past is always behind us, the future is always ahead of us, so progress is unavoidable. But the better question is, progress towards what? In modern parlance, progressive is a code word for advancing a secularist, materialist philosophy which treats pleasure as the greatest good and pain as the greatest evil. Pope John Paul II decried what he called a culture of death, where human life was devalued to the level of a commodity. He consistently called out the evils of abortion and euthanasia and diagnosed a culture of death that grew out of a wrong understanding of suffering. In that culture, choice and consent are elevated, or autonomy, as Patricia said, because they allow atomized individuals to determine for themselves what will give them pleasure and how best to avoid pain. Of course, not everyone is entitled to exercise such choices. Babies in the womb are a notable class excluded from the right of self-actualization, but this is justified, so the argument goes, because they're not thinking beings like the rest of us. Extreme sexual freedom, bounded only by the requirement of consent, is encouraged because it allows for the greatest exercise of choice in pursuit of pleasure, all the more so if it's successfully separated from the begetting of children. So, sterile sexual activity, whether artificially interrupted between members of the opposite sex or of its nature when practiced between members of the same sex, is no less valuable than procreative sex within marriage. And speaking of marriage, traditional conceptions of marriage in terms of permanent commitment and even the complementarity of the sexes are obstacles to be cleared away. Even biological obstacles to the pursuit of pleasure, such as the constraint of one's own physical sex, become a problem to be solved by human ingenuity with drugs and surgeries. And while that ingenuity has yet to solve the enduring problem of death itself, the progressive vision calls at least for us to be able to exercise control over it to the greatest extent that we can. Now, looking as I do at the matter from a religious perspective, it's difficult not to see death as a unifying centre of this awful pentagram. 1, the death of marriage as traditionally understood. 2, the death of procreative sex. 3, the death of the child in the womb. 4, the death of biological sex as a defining characteristic of humanity. And finally, 5, death itself. So while I would not regard the advent of legal assisted suicide as progress in the right direction, it is undoubtedly progressive in the sense in which that term has come to be understood by the people at large. And that's no accident. Since the 19th and early 20th centuries, technological progress has worked marvels that our ancestors could scarcely have imagined. The natural sciences, being concerned with material things, have seemed to show us a path leading ever onwards and upwards to better and better outcomes. Materialists on the moral plane have sought to jump on that train so that moral development too is presented as proceeding on an onward and upward trajectory all the time. You don't agree? What's the matter with you? Why are you against progress? Progressivism in this sense has never confined itself to one battleground. It fights on all fronts at all times, and the law is no exception. Since the mid-20th century in particular, the progressive legal project has sought to achieve, by judicial decision, victories that were not yet thought to be achievable by political means. Lawyers and their clients have repeatedly invited constitutional courts to discern in national constitutions rights that lack a textual basis, where the recognition of those rights serve progressive purposes. On many occasions, the courts have accepted those invitations. One such case was in the United States in the 1965 case of Griswold versus Connecticut. And the Supreme Court there struck down a law passed by a democratically elected legislature that banned the use of contraceptives. The basis for this was a right to marital privacy, which is not expressed in the United States Constitution, but which the majority of the court held could be found, quite literally, in the shadows. Justice Douglas, who wrote the majority opinion, said that specific guarantees in the Bill of Rights have penumbras, formed by emanations from those guarantees that help give them life and substance. Various guarantees create zones of privacy. A penumbra, of course, is just a fancy word for a shadow. It's hard not to see in the resort to language of this nature something resembling what poker players call a tell. When rights exist only in the shadows, it's questionable whether what they're protecting is a substantive good. As I recall, our Lord had something to say about what was done in darkness. The Griswold decision imposed upon the United States a new law incapable of being changed by any legislature, whereby contraceptive use could not be prevented. At the time, such an outcome was probably unachievable through democratic means in many states or regions, but judicial fiat eliminated further debate, and in response, the culture shifted in a decidedly progressive direction. Further decisions followed, most notoriously in Roe versus Wade in 1973, which found in the United States Constitution a right to abortion, deriving from, again, a shadowy right to privacy. In Ireland, a similar pattern can be detected. In 1973, in the McGee case, our Supreme Court held that the Irish Constitution also contained a right to marital privacy, which led the court to strike down a law prohibiting the importation of contraceptives. This was described as an unenumerated right, that is, one that could not be found in the text of the Constitution. Since the 1970s, it has been mostly one-way traffic in terms of judicial decisions advancing the progressive project. In the United States, the Obergefell decision in 2015 effectively legalized same-sex marriage. In Ireland in the same year, the same result was achieved, but this time by democratic means through a constitutional referendum. So it was in that historical legal context that the Fleming case came before the Irish courts in 2013. Now, many of you will remember that case brought by Mary Fleming, known as the right to die case, or among lawyers rather more cynically as the right to costs case. It was, in essence, an attempt to further the project of assisted suicide by judicial fiat. Now, ostensibly it failed in that the Supreme Court rejected the proposition that there was in the Constitution a right to suicide or assisted suicide. However, certain remarks made in the course of that judgment nonetheless gave what some see as a nihil obstat, or go-ahead, to the Oireachtas to legislate. That case, which is still the leading authority on the issue, concerned a woman suffering from multiple sclerosis. Relying on her right to autonomy and to bodily integrity, her legal team argued that she had the freedom, as someone enduring unbearable suffering, to end her own life. She also wanted assurance that her partner, who was willing to assist her in ending her life by suicide, would not be prosecuted after the event, nor face the consequences of the law. Although suicide itself was decriminalised, some of you may remember, in 1993, there was still a provision on the books that stated that anyone who aided, abetted, counselled or procured the suicide of another was guilty of an offence under the Criminal Law Suicide Act 1993. Counsel for Ms. Fleming sought to couch her argument in restricted terms. These things always start that way. We saw the same thing in the abortion debates. So it's not surprising that her personal story and her suffering were emphasised, as was the fact that this was a terminal, untreatable disease, and also that Ms. Fleming was compos mentis and was still able to make an informed decision. In other words, her consent was assured. This was not a decision taken under duress from anyone else. Her condition was terminal. She didn't want to die of her illness, but rather at a time and place and in a manner of her own choosing. Her legal team even went so far as to describe the proposed method of her demise, which, as the court said, involved a system whereby a lethal drug could be delivered to her and by her, but comprising a complex set of steps that would require assistance from others so that she could take the final step to kill herself. These things were not strictly relevant to the legal question at hand, but they were highly relevant to the battle for public opinion. In a referendum debate, these would be the things on which proponents of assisted suicide would focus. Now, while Ms. Fleming's illness and its stage and severity would evoke sympathy in the most hard-hearted person, they do not go to the central question of whether someone has a legally enforceable right to commit suicide. The 7-judge Supreme Court panel in the Fleming case considered the issue and came to a unanimous decision. The court, first of all, rightly concluded that the fact that suicide had ceased to be a crime when it was decriminalised, as I've said, in 1993, did not establish a constitutional right to suicide. In other words, just because something is no longer illegal does not make it a positive right. They further held that there is no explicit right to commit suicide or to determine the time of one's death in the Constitution. The court therefore said that the right sought to be established by Ms. Fleming, the right to assisted suicide, would have to be found within some other right, whether expressed in the Constitution or unenumerated in the shadows. On this occasion, however, the attempt did not succeed. Counsel for Ms. Fleming made the logically difficult argument that her constitutional right to life, which is protected under the Constitution, also encompassed a right to die. He attempted to rely on the 1996 case of In Re Award Withholding Medical Treatment No. 2 case, but the Supreme Court rejected that argument. It said that although the court in that case had allowed the withdrawal of food and hydration to the young woman in question, because it judged the tube feeding to constitute medical treatment, although a lot of people would disagree about that, it had not established a right to terminate life or have it terminated. It did decide that there was a right to die a natural death or to let nature take its course, but not that life could be ended at will. Counsel for Ms. Fleming also argued that the ward... Counsel also argued that the ward, the young woman, like everyone else, had a right of autonomy, including self-determination, resulting in a right to determine the time and meaning of her own death, and that the right to determine the course of one's life extended to the right to determine the timely manner of its end. But this was ultimately rejected by the court as being inimical to the social order contemplated by the Constitution and the values reflected in it. However, the court did make a statement that has proved to be controversial and problematic, and it's one, I suspect, that was made from, that perhaps stems from the member of the court either falling prey to feelings of genuine compassion unmoored from reason, or else personally believing in assisted suicide but struggling to find a constitutional basis for allowing it. Or perhaps both were at play in the minds of the members of the court. Who knows? Judges are human, like the rest of us, and even the Supreme Court can get things wrong. It's one of the reasons it reserves it to itself the right to reverse its own decisions. But I want to read that passage to you because it's on the basis of this passage, that the idea of the introduction of legislation for assisted suicide has gained traction. It says, it was delivered by the Chief Justice Denham, and it says, "Nothing in this judgment should be taken as necessarily implying that it would not be open to the state, in the event that the Oireachtas were satisfied that measures with appropriate safeguards could be introduced, to legislate to deal with such a case as that of the appellant. If such legislation was introduced, it would be for the courts to determine whether the balancing by the Oireachtas of any legitimate concerns was within the boundaries of what was constitutionally permissible. Any such consideration would necessarily have to pay appropriate regard to the assessment made by the Oireachtas, both of any competing interests and the practicability of any measures thus introduced." Now, notwithstanding the fact that this is what's known as an obiter dictum, or an incidental remark not essential to the judgment and therefore not binding, for many people this seemed to be an encouragement or a nod to the Oireachtas to go ahead and legislate. Despite failing to find a constitutional basis on which to acknowledge a right to suicide or assisted suicide, some lawyers are of the view that this is evidence that the Supreme Court views the Oireachtas as having the competency to legislate. So what implications, if any, do this judgment, and particularly the obiter dictum, have for Irish law and for the campaign to legalise assisted suicide? Well, I think the short answer is, no pun intended, that it has given the campaign to legalise assisted suicide a shot in the arm. All the efforts on the side of those who wish to legalise assisted suicide have been on the legislative front. Politicians have been won over in exchange for favourable media attention. Government officials and departments are looking into the matter. There has been an Oireachtas committee and report on the issue, and 2 private members' bills have been proposed, all of which basically amounts to a scoping and softening up exercise before government parties bring in a bill of their own. So the question then is constitutional change required to allow for assisted suicide? There remains no right to commit suicide in Irish law under the Constitution, yet there has been little or no talk about a referendum on the subject, perhaps because of the Supreme Court's obiter comment. But the question is, can the Oireachtas legislate on this issue? At the outset, it has to be recognised that there are statutory laws in operation, that's those that have been enacted by the legislature, which are not necessarily founded on a constitutional right. So in principle, the fact that there is no constitutional right to a particular thing does not necessarily preclude the Oireachtas from legislating to allow it. This is consistent with the general idea that all things are permitted that the law does not prohibit. However, in this case, there's a very strong argument, I think, that it is impermissible for the Oireachtas to legislate. And that point has been made very persuasively by Dr. Conor Casey, an Irish legal academic currently at the University of Surrey Law School. And as he contends, the Oireachtas passing a law to allow third parties to be involved in the intentional killing of another person, notwithstanding their consent, which can be very difficult to be assured of in practice, would directly offend against the duty of the state to vindicate the right to life of every citizen as set out in the Constitution. And I think that's perhaps the best and clearest argument against the Oireachtas legislating. There's also the difficulty inherent in the issue of legislation that it can be challenged, or elements of it can be challenged before the courts. Now, this can work both ways. On the one hand, it could be struck down as being unconstitutional. On the other hand, and being mindful of the Supreme Court's comments in the Fleming case as an indicator of judicial views on the matter, it could well be found that the Oireachtas has a right to legislate, and that any restriction on a right, and I think Johan spoke about this, any restriction on the right to assisted suicide could be unconstitutional because of the equality guarantees in the Constitution, or because of the rights to autonomy, self-determination and privacy. That's to say, the courts might have resort to the shadows once again to bolster enabling legislation and ultimately to extend it. So whether occurring by virtue of judicial decision or further legislation, it seems likely that the trajectory of any law on assisted suicide will be towards the relaxation of restrictions. Progress requires expansion and more of whatever right is established. We see it in the abortion legislation passed in 2019. It's simply not enough anymore for those who advocated for it at the time. They want less oversight and more access. It would be no different with this issue. What about a referendum? Would it be better to put it to the people rather than the Oireachtas? This, I think, is a case of be careful what you wish for. The proposal, when you think about it, would be to authorise a change enshrining a right to suicide in the Constitution. Can you even imagine the wording? Every citizen shall have the right to kill himself or herself, or possibly themselves, without distinction as to sex or gender, thrown in for good measure. The question to my mind is not so much whether the people should be free to decide, but rather whether it is right in principle to put the question to them at all. And my view, and I held the same view in relation to the abortion referendum, is a categorical no. At the time, I said it would be wrong to hold a referendum on the matter because the right to life of the child in the womb was, as a human right, already an inherently anti-majoritarian device that protected a vulnerable minority. To allow the majority to get rid of it undermines the whole idea of human rights. Now, the circumstances are somewhat different here in that the threat to the person comes not from a third party, as in the case of abortion, but from the person themselves. However, I think the principle is the same. A referendum on the issue would essentially be asking the people to vote for a measure which is an attack on a vulnerable person's right to life and destructive of the state's existing duty to vindicate that right. It would be a vote to legalise killing an innocent person. As things stand, the state has a duty to protect every citizen's life from unjust attack. And although it's yet to be tested legally, I think it's reasonable to say that a person can pose a threat to him or herself, that an unjust attack can be self-inflicted. Historically, the law recognised that people who are insane may pose a threat to themselves or others, and that this may even justify depriving them of their liberty. While the threat to others is part of the calculus, the person most at risk from a madman is the madman himself. This then can be viewed as a form of protecting a person from himself, of vindicating his right to life when he himself is the person threatening to infringe upon the right. There's of course also the consideration that, in my view, to enshrine a right to suicide or assisted suicide in our Constitution would be a terrible moral outcome. It would be progress only down a road to hell. The court in Fleming suggests that the state doesn't have to go to great lengths to prevent a person from committing suicide, though it does say that the state is required to seek to discourage suicide generally. But it doesn't say why. And that really is the nub of the question. Why is suicide wrong? Why should the state, or anyone else for that matter, seek to dissuade someone from committing suicide? If we're all private, self-determining citizens with a right to do what we like with our own life and our own bodies, why shouldn't we have a right to suicide, so long as we consent to it? Now, we can talk about the legality of this issue all day long, but fundamentally, just like the abortion issue, this is not a legal matter. It's not really about the law at all. The law is only a means of allowing it to happen. It doesn't tell us whether it's right or wrong. Our positions on the issue of assisted suicide are ultimately governed by values and morals, and that in our culture, is where the real fight lies. However, the interaction between law and politics and culture is complex and rarely unidirectional. Each influences the others. The law is a teacher, and the changes in the law often influence cultural changes, which in turn influence the politicians who make our laws. Often, the semblance of a cultural shift is sufficient to bring about the legal change that will make the cultural change real. You don't have to bring everyone along, just enough voices to give the impression that the culture has altered. So, initiate a citizens' assembly, an Oireachtas committee, get personal stories highlighted in the media, especially those that are or claim to be adversely affected by the law sought to be changed. Have experts speak about the necessity of the change. Ignore and bury the testimony of dissenters, especially those with real expertise, experience and knowledge. And for good measure, highlight the fact that the Catholic Church teaches against the proposed change. That will definitely persuade all right-thinking people that the change is good. This is how the progressive playbook works. As I remarked earlier, it's warfare on all fronts at all times. That last mention of the church, rather than being merely a distraction, is actually central to the debate. Why? Because in opposing assisted suicide, the challenge in Western society today centers on the divide between believers and non-believers. It's not a question, as so many atheists have rather ham-fistedly attempted to frame it, of religious people imposing their views on others, because that's what those who support assisted suicide are attempting to do after all. They want to live in a society that denies the inherent sanctity of life. I, and I'm sure many of you here, want the opposite. That's a philosophical and even theological dispute on which both sides cannot simultaneously prevail. Each side is seeking to impose its view on the other. The "don't impose your views on me" objection is therefore one of the most stupid comments that can be made. Anyone who lobbies for a particular law is seeking to impose that law on everyone in society. The real question rather centers on the difficulty of articulating why suicide in all its guises, including assisted suicide, is wrong if you don't believe in God. To illustrate this, and in order to consider what the dangers inherent in such a law are, I think it's worth giving some consideration to the draft legislation, the Voluntary Assisted Dying Bill 2024, and actually the word suicide, Patricia, isn't in the title, Voluntary Assisted Dying. That was introduced by Gino Kenny TD, but which has since lapsed. But this is a second incarnation of a bill previously introduced by Deputy Kenny. The fact is that it's very difficult to limit assisted suicide once it's accepted in principle. Now, Patricia mentioned Posner's hypothesis, which is clearly meant to allay our fears by suggesting that suicides will decrease. Every advocate for assisted suicide and every draft bill proposing it, including the 2024 bill, mentions restrictions, limitations, conditions, safeguards. Although, as with abortion, I wish they would tell us why safeguards and limitations are needed. Why should we want to reduce numbers if what they're proposing is so good? If, as they suggest, it's a morally neutral act, why limit it? Talk of restrictions and limitations is largely meaningless if the basis for allowing it is that someone is enduring unbearable suffering, which is what the 2024 bill proposes. The difficulty is that all suffering is subjective. One person can endure what another cannot. Who's going to turn around and say, your suffering doesn't qualify because despite what you think, you can bear it? What legal principle or constitutional right can be invoked to say one person's suffering is worse than another? If everyone has equal rights, and there's found to be a right to suicide, which is essentially what was argued in the Fleming case, then why shouldn't anyone be entitled to kill themselves when and how they see fit? Now, you may say this is overstating things, things would never go that far, But all one has to do is look at the text of the 2024 bill to see the future. The wording there states that a person must be, and I quote, experiencing unbearable suffering that cannot be alleviated to a level the person finds acceptable. So the wording here betrays the true intent and worldview of those pushing for assisted suicide. It's completely subjective, utterly free of any standard of measurement. It's also completely unscientific. It is not medicine. Once the principle of assisted suicide is established, whether as a constitutional right or otherwise, then on what basis can we argue that someone doesn't also have a right to suicide itself? Someone else is allowed to help you to commit suicide, but you can't do it yourself? It would be a nonsense. So the two stand or fall together. Once the right is recognised, what is the basis for restricting it? Now, early legislation, the foot in the door, as I was speaking to somebody at the coffee break about, may include restrictions. Often, these are what persuade the public to open the door a crack in the first place. But once the foot is wedged in there, the door rarely closes. On the contrary, the opening is just made wider, whether because judges hearing cases decide that the legislation unfairly discriminates against some poor person just on the wrong side of the line where permission ends, or because the legislature, in an exercise of compassion, draws a new line in the sand, and then another, and then another. And so we find ourselves coming full circle back to the moral question. We can talk about the slippery slope and about the risk of pressure being brought to bear on those who are old or infirm. We can talk about the contagion effect, and all of these are valid points, but they don't address the central question of about suicide. Our moral response to assisted suicide begins with what we think about suicide itself. We need to ask the truly fundamental question, is suicide wrong? And we need to be able to answer it and communicate that answer to the society in which we live. For the person who believes in God, the answer is an easy one. Yes, suicide is wrong, because our lives are not our own. Our bodies are not our own. Our freedom and life were bought at a great price by one who loved us more than we can ever comprehend. This world in which we live is not our true home. It's a staging post while we wait for our real life to start. And to gain admittance to our new home, we will be called to give an account of ourselves and our actions and our omissions throughout our life. It's because of our recognition that all life comes from God the Creator and is impressed with His image and likeness that each life has inherent worth. The fact that each of us is a creature of God is testament to our shared heritage and underscores the fact that though there seem to be great inequalities between us, we are required to treat each other with equal dignity, respect, and for the Christian, love. Suicide, then, is a rejection of God's gift of life to us, and ultimately a rejection of His whole creation. If you don't believe this, if you don't believe in God or the next life or sin or judgment, it's difficult, logically, to argue against this culture of death. In your worldview, ultimately, if there's no higher authority, then in a sense you are yourself a god. Why shouldn't you decide what you want to do with your own body? This is the central idea of that pentagram of death: sex, abortion, marriage, one's own sex, and ultimately one's own death. Your right to choose and exercise complete control over all these things. Why not? There's a real difficulty for atheists to make a convincing argument against suicide that doesn't descend into circular reasoning or contradictory or frankly hypocritical arguments. Ultimately, in a world without God, everything is simply a matter of preference. Now, some atheists will say suicide is morally wrong in the same way that selling oneself into slavery is wrong. But why is that wrong? If the person consents to it, why shouldn't he or she decide to do so? Another might say suicide hurts others, particularly friends and family. But in a world without God and with no afterlife and therefore no consequences or accountability, why do we have a duty to others? What do their feelings matter to us after we're gone, or even before we're gone? Secular humanists might argue that life has intrinsic value in itself, but again, if there's no God and we're just a random collection of atoms that has magically morphed into a living being, why does that life have more value or dignity than other life forms? Or why does it have any value at all? When we don't believe in God, we can dispose of others in a suitably civilized way, of course, whether it be in a luxury pod or a hospital bed surrounded by technology, and never have to think about them or worry about our actions because there are no consequences. Once the law is on our side, we don't have to worry about being accountable to anyone. But of course, religion tells us that there's always consequences to our actions, even if we don't see them, and that we might only feel some of those consequences in the next life. So for this reason, for the advancement of the Progressive project, religion must be either suppressed or destroyed in some other way. Historically, suppression and punishment have had some unintended consequences. Specifically, that when people are persecuted on account of their religion, it tends to bring out their virtues and faith all the stronger. That's why we in Ireland were once known as a nation of saints. What's much more effective in destroying religion and its practice and belief and the morality it demands is actually allowing a freedom of a sort, as in not openly suppressing it, but undermining it at every turn. G.K. Chesterton, before his conversion to Catholicism, wrote a book entitled Orthodoxy, and in it he writes about suicide and describes it as the sin to end all sins. He says, "The man who kills a man kills a man. The man who kills himself kills all men. As far as he is concerned, he wipes out the world." Chesterton saw it as an act of treason against the world and the ultimate insult to God, which it is. That's not to say that there may be very many difficult circumstances at play in which a person feels driven to suicide, but very many wrongdoings have some difficult circumstances behind them. The suicide, says Chesterton, is the opposite of the martyr. A martyr is a man who cares so much for something outside him that he forgets his own personal life. The person who commits suicide is a man who cares for so little outside of him that he wants to see the last of everything. Now, those words may seem very harsh to modern ears. There's much greater understanding these days of mental illness and suffering, I hear you say. But is there really? Why does there seem to be so much more mental illness around? Which is kinder to say, suicide is a sin. You need to know that before you decide on it. Because as great as your suffering is now, eternal suffering is much worse. I'll hold your hand. I'll help you cope. I will ease your pain as best I can. Or to say, suicide is a completely reasonable response. You've suffered for far too long. You don't need to anymore. I'll help you end it all. Then you'll have no more suffering and pain. Which response makes for a better social order, for a more compassionate and loving society? Do we get rid of the weak and the vulnerable, or do we look after them? Do we encourage people, each other, through thick and thin, or are we indifferent to others, not caring if they give up and lose hope? Do we give what is our due to our Creator, or do we insult him? As the book of Genesis teaches us, without God, all things lead to death. With God, however, there is life, everlasting life, and that has consequences for our thinking and our decision-making. That's why, ultimately, all human rights stem from the Church's teaching on the inherent dignity of man. And although the human rights industry has been taken over by secular humanists and atheists, its foundation is Christian. If that foundation is undermined, it's simply a matter of time before the whole edifice comes crumbling down. Now, looking around, it might appear that all is lost, that further progress is inevitable. But there are signs for those who wish to see them that the pendulum might be changing direction. After 60 years of accumulating one judicial victory after another, in 2022, the tide suddenly changed. In the Dobbs decision, the United States Supreme Court overruled Roe versus Wade and held that it had been an error to find a right to abortion in the US Constitution. It's interesting to note that at the time of the decision, 6 of the 9 members of the court were Catholic. On those who struck down Roe versus Wade, there were 5 Catholic judges and 1 High Anglican. Observers of political culture in the United States will not have failed to notice the disproportionate influence that Catholic thought is now having on that country. The consequences of the decision have, however, been mixed. Certain states held referenda seeking to enshrine abortion rights in their constitutions, and these generally passed, an instance of the culture not keeping pace with developments in the law. However, what this means is that the secularist, materialist worldview is no longer countercultural. It is the prevailing culture. And that culture is increasingly being found to be unsatisfactory by a younger generation who are looking with fresh eyes at what the discarded religious traditions have to offer. There's hope that, as happened in the 1960s, change in the law brought about by an intellectual vanguard may prompt changes in the culture, which could yet be for the benefit of us all. It's to be hoped that the path towards legalized assisted suicide may be more obstacle-strewn and difficult than its proponents imagine. On this issue, as with many others, the best form of progress would be to turn around and march in the opposite direction. Thank you.